just answered.
If you look at the charge sheet, it talks about the meeting and the 20th.
And the 20th. It's a contradiction.
So that's what I'm saying. It is important, therefore, that my colleague makes the reference to the fact of instructions, remembering that the accused persons have been held in Comunicado. We were not allowed them to even to see them this morning until they came in the court. And then I was talking to them, I was
Let
him finish.
During their application, they were referring to the same affidavit. They were referring, the colleague that before the meeting referred to the same affidavit, trying to tell the court that they should deny my client bail. So it is.
When you talking about the other issue, you have talked about the when he was arrested, when they were arrested. Let us do it. If you are not arrested on the day, please there. Let them tell us that. Tell us when you are arrested. Because I don't even know why they are arrested.
But they are here.
Yeah,
almost. They don't have to swear. They don't have to swear. That's it.
Okay, fine.
Because it's wrong.
It's okay. It's okay. I have no problem with that. But I'm saying, if
Well, Your Honor, I'll proceed to the next point. In this very affidavit, the CIP swears, I find paragraph number 12. He swears in support of the prosecutor's application to deny each of the respondents' bail. Verbally, they've submitted that they are only opposing bail for the first respondent, for the first accused. So it demonstrates prejudice and abuse of the whole process, because why haven't they indicated why they've only changed their stand on the position of bail for only one individual in the same matter? I would also like to refer the court to paragraph 10. Sorry, paragraph 8. That being an influential person in the Republic of Kenya and a known leader of the outlawed Mobutu sect. Now, this is speculation because it has not been proven for any court. And it is unheard of that in any jurisdiction in the world that anyone has ever been denied bail because they are influential, or your notability provides that because of how famous you might be or well-known you might be, you know that negates or it diffuses your right to bail. I would also like to refer the court to the Criminal Procedure Code Act, Section 123, which stipulates very clearly 123, the Criminal Procedure Code Act, which stipulates the charges, the crimes that one will be charged for, and the possibility of getting bond will be lower. I'll have the court know that the charges presented before this court are not stipulated in that act. The act also gives this court jurisdiction and autonomy to give favorable and not excessive bond terms to all accused persons with respect to what I just mentioned up there, that what they are charged with is not included in the very exempt circumstances where people are denied. I'd also like to highlight the court that in the same nature that the first accused person is a very well-known person, and therefore he's not a flight risk. Why am I saying this? I'm saying this because if you're notable, it is incredibly difficult I'm just presenting an option.
They have not said they are.
Let me proceed to the next point. There's a clause, there's a paragraph that indicates that he might intimidate the witnesses. I'll have the court know that the witness is a police officer who is armed. And the allegation on paragraph 8 that the client might cause harm, rather crucial harm to the witnesses, which I find very problematic because they're saying witnesses and the only witness that is indicated is one witness. So where is the evidence that this accused person is going to present, or rather might cause any danger or crucial harm to the witness who is an armed police officer? So I submit that if somebody alleges something and I refer to the Evidence Act, they must prove that indeed this individual poses a threat to the said witness. That is all.
This is an unlawful, it's illegal and unconstitutional. It is seeking to subvert the Constitution, like the same way the investigator has subverted the constitutional rights of the classes. And emphasize the point that is read by the colleague. A, the accused person, especially the first accused person, is not convicted of any offense. He may have been arrested at least because this has become the police state. Like I said earlier, we are going backwards rather than moving forward. The grounds are on which this Chief Inspector Gideon Moi relies on are speculation. This is not what a police officer should like. Neither should have even an investigator, a DPP approve such a charge sheet. But more importantly, the charges facing the accused persons are themselves dubious and doubtful. When they say there are 24 Maasai assaults and Maasai wounds, the charge sheet itself is closest, therefore, than this equipment that do not belong to them. They belong to Maasais who are not disclosed. I don't know whether Your Honor is on social media, but we have seen, and I read the post that you notice, we have seen clips circulating of people of government supplying machetes to people, not to the accused persons. No, it needs to go on record. You may rule me out of order.
Your Honor, these are very learned senior colleagues. They know the rules of the game, but they keep flouting them. Council knows how we would deal with the questions of material on social media. There is no material before you, there is no certificate of electronic evidence.
JB, we appreciate you. if only you could have followed the law, we would not be here.
No.
Council, I respect you. I will not
I don't want everybody to speaking. I don't want to say I'm not putting what I said.
Thank you.
Yes,
Yes,
they show the certificate. I want one person to address me at a time.
Yes. The other point I wanted to raise is the fact, in terms of the facts on the chart sheet, they're talking about Kisii area within Kajiado County. Kisii area is very large. What are the particulars that will ensure that the accused persons understand the charge? Kisii is not a constituency, it's bigger than a constituency, it's a sub-county. They have also been charged with organizing, and I think my learned colleague referred to that we know what has been happening since last week. We know who called the demonstrations of the country. It's not the accused persons. We know it's Raila Odinga and Azimio Party, and they don't belong to Azimio Party. Are they Raila Odinga? So why charge them? Then they are being charged with something very strange called subversive activities. Now, subversion, to the best of my memory, is a charge that was amended and removed from the Penal Code under the security sector laws amendments. But more important, the accused persons are three. Then they are the fifth account rather, suggests that they were having an invitation to incite members of the public to violence. There are no particulars in this charge that demonstrate what activity they were doing for incitement.
I think I don't want to stop you. Yes, you know what? The application is for vote.
Yes.
Yes, the application. You see, now you are trying to argue and you need to invest there. And that issue is accused about the issue, the cash does not disclose particulars and it's useless, blah, blah. And I've already addressed that.
No, my point, the point I was working so I
The
apologize.
point you are raising, yeah, they are not attacking the right. Wait until the right moment when you get there.
No, the
I've already
point-
ruled about the issue of whether the judge is useless or not.
If you communication with me, that's a little bit.
Yes.
The point I'm trying to make by this demonstrating the weaknesses of this charge is that there is no likelihood of conviction, and therefore there is no need to deny anyone a bail. That's the point. But lastly, yes, I'm saying that the charges are so weak that they are unlikely to raise a conviction, and therefore there is no need to deny the board. Lastly, before I give 1 minute to my colleague here, Mr. Odido, I want to say that in the application we have some photographs and some electronic documents, but there is no certificate as required under the Evidence Act. So this application must be rejected. I will not agree also to the video with your permission. Thank you.
You know, as brief as
This is one bring about 3 people. So if we proceed to bring like that, yeah,
you want to just do 1 minute. I will not proceed more than 1 minute. If I'm sure.
I don't speak what I say.
I will not repeat what has been said. I will not repeat what has been said. You know, other than my senior insinuating that the fee that we put before you in the court is not only legal but unlawful, it is also important to note, Your Honor, that the state affidavit is only premised on 2 grounds which they are alleging. Number 1, Your Honor, the prosecution alleges before you that one of the grounds in that affidavit is that they are apprehensive. It's a mere apprehension. That is the first ground, that it is simply premised on being apprehensive. And the second ground is that they question what they call the character of the accused person before you. You know, we cannot talk about the question of apprehension at this point, because this is a settled position and settled law as we speak. The case of Oscar Sudion versus Republic, as decided by Justice Joel Ngugi, that is a criminal appeal number 208, Your number 208 of 2020. Criminal appeal number 208 of 2020. You know, the court stated clear that the prosecution cannot rely on the question of apprehension, that they're just merely apprehensive, that either the accused person will interfere with witnesses, or either the accused person is in danger. They need to prove two things which they have not proved. That number one, the threat must be factual. They have not proved that. And that number two, the threat must be independent. They have not highlighted specifically which threat is this. You know, number two, on the question of the character of the accused person, the prosecution has simply presented an affidavit before you telling you that the accused person is a repeat offender. You know, it has been demonstrated before you. They say that and
That one,
but it's okay.
and I did not even put it on paper.
They have
Because
said
it's not an offense, it's called what?
it is Your Honor, they have said clearly that the accused person is of a similar character, which has happened before, and that there is an existing case. But what they have not disclosed before you is the position of that case. You cannot determine that a person is of a similar character if he has not been convicted. Article 50 is clear of the rights of conviction. Lastly, Your Honor, they have demonstrated that the life of the accused is in danger because of a similar sect likely to attack the accused. They have not demonstrated to you what is this sect? Does it even exist? What's the name of this sect? Number two, what are the issues between these sects? And number three, Your Honor, what has the government or what has the prosecution done about this illegal other sect existing? They have admitted before themselves that the accused person is a non-influential person. And as such, it is clear it is of a board fixed aboard and it's not a No, I'm just saying, if they've said it's a non-influential person, you know, in other jurisdictions, persons who have been admitted or who have been declared to be of a non-influential person and who can be found have been even been placed on a free board in other jurisdictions. You see? So, Your Honor, we pray that the first accused person is not a fight. And if by any chance you are going to make a determination on the bail terms, the bond terms, we pray that the first accused person, if possible, even be released on a free bond, because he's known to the prosecution. His place where he lives, they know. Where they arrested him, they know. Where he stays and his family is. So, I will be okay.
And I hope the court has ignored the last part. We are not in the business of knowing where people live in the prosecution.
That is your business. This is
We are not proceeding like that. No. Do you have anything to say?
Yes, please. We have
I want an
response.
Just one point.
No. We are not going to proceed that. I'm giving you time. I even added a third advocate.
I apologize.
Can I try to?
One, the accused persons were sentenced to death by the High Court, and that matter is still alive.
It has been stated and even the ruling has been given there.
Thank you.
Thank you. I'll try to just brief as possible. I'll start with that last question. My name is Owiti, O-W-I-T-I. I'll start with the last question of the High Court ruling. We have been served duly with the ruling dated 21st July 2023. Indeed, granting the accused persons, the applicants therein, miscellaneous criminal case number E270 of 2023. However, I would invite the court to look at order number E, and I know the court is limited in time. You'll allow me to read this. That for the avoidance of doubt, the DPP, the fourth applicant, is at liberty to present any charge, which is what we've done this morning, against the applicants in any court, which is your court. And as such, and this is very important, the trial court will be at liberty to set any new terms, bail, and this is even more important, or determine whether or not to grant bail. So they didn't bring that to you. It's deliberate and it's understandable. We pray that as far as the order is concerned, this court was allowed by the High Court that gave the orders to determine whether or not to grant bail, and therefore our application is properly going. Articles 29, Article 27, just naming a few, and a number of other articles of the Constitution have been raised. I reiterate my submissions before you this morning that Section 8 of the Magistrates Court Act limits your ability to entertain any applications on the provisions under the Bill of Rights to Article 25A and B only. The learned senior, Mr. Ondieki, attempted to invite you by the provision of Article 10 on the national, the principles and national values, that you have a right to protect the Constitution as you interpret the Constitution. The Constitution only obligates the High Court under Article 165 to interpret those other provisions of the law, including 19 and 27. Because of the limited time, I'll invite the court to look at the decision of the Supreme Court in Hussein Khalid. Hussein as a double S, Khalid is KH, and 16 others versus the Attorney General and 2 others. Petition number 21 of 2017. 21 of 2017. I will invite the court to look at paragraph 118 and 119. 118 and 119. Your Honor, because of the seriousness of the push that you interpret the Constitution, allow me to read a brief of paragraph 119. This is what it says. It consequently follows that the position in which the appellant sought to clarify regarding the jurisdiction of Magistrates Court in dealing with enforcement of the Bill of Rights has since been addressed by Section 8 of the Magistrates Court Act. However, the legislation was not enforced when the appellants were first before the Magistrates Court, and the Magistrates Court at the time rightly applied the applicable law. Parliament has granted to the Magistrates Courts power to consider applications on alleged violations of the Bill of Rights, but has limited that power to only 2 rights under Article 25A and B of the Constitution. So that settles the question as to whether you can deal with those other provisions. There's the issue of whether or not there has been a limitation of the rights of the accused persons, whether properly or otherwise, under Article 24. Indeed, Article 24 of the Constitution allows for the limitation of rights. But again, as we've said, that is outside your jurisdiction. There's the question of varying dates, either in the charge sheet or the application or the supporting affidavit. As you can see in the affidavit, the date of 18 is the date of receipt of intelligence. It's the date of 18. Let me just point the court to the relevant paragraph. That's paragraph 2 of the affidavit. Indeed, the charge sheet refers to 2 dates. Count 1, 20th, count 2, 20th, count 3, 20th, count 5 as well 20th, count 419. We invite the court to invoke section 382 of the Criminal Procedure Code, which allows for correction relating to dates and other things. That a charge cannot be invalid by dint of a wrong date. That should be read together with the power of this court of amendment of charges, which allows the prosecution or this court suo moto to direct that a charge is amended. That right and power exists until the accused person is placed on their defense. We are very far away from that. There has been a
There's some other people who know we are not going to serve one person. The other people want to be served.
the issue of what is compelling reason and the burden of proof thereof as a recent. Plethora of cases in the Republic will have this court agree with us that while the burden of proof of the existence of a compelling reason exists and is vested on the prosecution, the standard of proof of a compelling reason is distinct from the standard of proof of a criminal case. We are simply to prove the existence of a compelling reason on a balance of probability. If I was senior Mr. Onyeki, I would say there was some misapprehension of the law. The suggestion that we need to prove the existence of a compelling reason beyond reasonable doubt is out of law. So we argue that we have proved compelling reasons on a balance of probability. That explains, Your Honor, why we are using the words likelihood, apprehension. Those are words that appreciate that the balance, the standard of proof of compelling reasons is a balance of probabilities. I then invite the court to look at clause 4.9c. Clause 4.9c of the Judiciary Bail and Bond Policy Guidelines. And the reason I'm raising it, Your Honor, is that 4.9c, which talks about character and antecedents. The reason we raise it is that counsel referred you to section 123, which makes a distinction between offenses and whether or not bail can be granted. Post 2010, again, because that was a misapprehension of the law, all offenses are bailable. However, clause 4.9c says that a person can be denied bail on the basis of...
The problem is the delay in that issue.
That's a point of law.
That's
That's a point of law. I can raise it.
That's for a new one. We have no right to respond.
You want to protect me? This is a point of law.
I'm saying, address the
We have no right to respond.
No, this is a question of law. You don't have a right to respond to it. Clause 4.9 talks about denial of bail on 4.9c on the basis of previous character and antecedents. If you look at the whole of clause 4.9, it lists a non-exhaustive list.
Your Honor, we must object to this submission because that document is talking about, it's a policy document, it's not the law.
Yes.
So you can't
Okay,
you can't
the
say
law.
Let's just finish up what they're saying.
Your Honor, clause 4.9 of the Judiciary Bail and Bond Policy Guidelines lists an exhaustive list of compelling reasons, and therefore the suggestion that there are no compelling reasons or they have not been defined, or that if they fall down there should be disaster, does not arise. Compelling reasons have been defined both by judicial precedents and by that clause 4.9. Thank you. I'm almost done. There's the argument that the accused persons should have been given an opportunity to study charges. That is not what Article 52 expects of the court and the prosecution. The accused person should be given sufficient time to prepare for their hearing. If they are not ready for hearing today, which we don't think we are going to proceed today, they shall have time. And the advocates, now that they are before court, will have an opportunity, whether outside, after bond is granted, or within the prison, to speak to their clients so that they get instructions. Finally, Article 27 has been raised on the basis that the prosecution has opposed bail only for the first and not the second and third. it is not discrimination, even if this court were to have power to hear questions of alleged violation of Article 27. It is not discrimination where compelling reasons have been proven against one person and not against the rest. In fact, it would be an interesting argument that the defense are saying if you want to deny one, then you must deny all the three. The law contemplates that if we raise compelling reasons only against one accused person, that accused person alone should be denied bail. However, as we have already said, you do not have jurisdiction to interpret Article 27. Thank you very much.
Up to that point, I'm this matter. I'll give a date for voting, then I don't think other matters for this.
You know, we were suspending the court unanimity can retire for 5 minutes.
For 5 minutes and
The court had done
it's a matter of exception.
No.
kindly that.
No. I don't want to go. I'm retired as well on the issue of, if you had not been intervention, I would have retired now to go and do the healing of form. But not because we raised other issues which may force me to go and retire and do a short ruling. Please give me time and give ruling tomorrow.
You're also requesting for the defense to supply the statements and
No, those issues, tomorrow, when I give ruling, I will give direction on how the matter is going to proceed.
And the accused is visibly unwell. He cannot even now speak well. We're requesting that within the rules tonight, he can be admitted to hospital. He's visibly unwell. There is a medication. Right now, he cannot be contact.
No. I'm saying, one person at a time. I don't want to be addressed by everybody now. Yes. I'm saying, say the name of this. So,
You know, I've been advised by seniors that industrial area police station. Sorry. Oh, sorry, I thought you'd invited me. My apologies. My apologies.
The first
Please.
accused is visibly unwell. The second and third accused have been given the medication here. Not all the medication that they require, but some of it. Your Honor, our humble application. This is not an application, this is a request. Is that they be given medical attention in front of it. So they can attend the court tomorrow.
You know, I'm advised by my seniors behind me that the accused persons be held at the industrial area prison, which has medical facilities. If there would be need for special medical facilities, a referral will come from the prison, and an order can be made accordingly.
You are the first accused person has special current hospital. Situation is even so the first accused is taking special.
Consider the request by the defense to have this person taken to the hospital. One thing I'm going to say is that I'm aware that there is a medical facility at the prison. I'm also aware that I'm saying that because I'm that facility. I'm aware that the officers at that facility, the person who has managed there, the medical facility, if it's an issue, the person can handle. So, for that reason, I would like to put that request. That is promoted tomorrow for ruling on paying bonds.
Thanks. You can come in the morning, the family.
You can come because I know I promise you. You come, it's the first thing. They are brought here early in the morning, 9 a.m. Sorry? They are looking to marry and they dash very
Much obliged, Your Honor, and thanks for your time. Thank you for.
We are most thankful.
Thank you.
So, for the viewers who are watching, Maina and Njenga has been taken to remand for the case to be determined tomorrow. He'll be placed by the court on bond or not. So he'll be taken to. So he'll be remanded at the community prisons where see what exactly is going to happen. But thank you so much for those who kept moving with us. So the ruling will be made by tomorrow at exactly 9. And, maybe if I can try to get the wakilis and to have a talk with them and see what exactly they're going to tell us. So in a short while, I'm going to